Welcome to the McNees Eminent Domain podcast series. In this video podcast, attorney Kandice Hull explains what is just compensation that is owed to landowners when their property is acquired by eminent domain. Ms. Hull leads the eminent domain practice group at McNees and is chair of the litigation practice group.
In this podcast, we will discuss exactly what is the just compensation that is owed to a landowner when his property is acquired by eminent domain. In 1893, the United States Supreme Court affirmed that the Takings Clause of the Constitution requires that a landowner receive fair payment when his property is acquired by the government, stating that when an individual surrenders to the public something more and different from that which is taken from others, a full and just equivalent shall be returned to him. The court held that compensation must be a full and perfect equivalent for the property taken. So what exactly do those phrases mean? What is the full and just equivalent that must be returned to the property owner? Compensation is generally measured as the fair market value of the real property that is acquired, determined on the date of the taking. Fair market value is the price which would be agreed to by a willing and informed seller and buyer in an arm's length transaction. The landowner receives the value of what he would have obtained from the property had he sold it on the open market. The intent of the standard is to place the landowner in a nearly identical financial position as to that which he would have been in prior to the taking. Prior to the condemnation, he held the real property as an asset with a certain value. After the taking, he has the monetary equivalent of the value of the real property. The just compensation standard intentionally does not capture the subjective value of the land to the property owner. This is understood to be the case for several reasons. First, it is very difficult to quantify the particular sentimental or emotional value a landowner may have in his unique property. Further, although that sentimental attachment might make the landowner unlikely to sell the property, it is not something he would recover in an arm's length transaction should he freely choose to sell the land himself. Thus, it would be making the landowner more than whole to pay for that emotional component of his attachment to the land. Additionally, the standard requiring the government to pay market value, but not more, ensures the landowner is made whole, but also protects the public treasury by not requiring the government to overpay for the asset it needs. In Pennsylvania, the standard for just compensation is very similar to the federal standard. Just compensation owed to a landowner for a taking is defined as the difference between the fair market value of the condemnee's entire property interest immediately before the taking and as unaffected by the condemnation, and the fair market value of the property interest remaining immediately after the taking and as affected by the condemnation. What that means is that the landowner will receive the value of the property on the date of the condemnation without considering any negative effect that the condemnation or potential condemnation had on the value of the property. If the condemnor takes less than the entire property, the landowner receives not only the value of the acreage or interest acquired, but also payment for any negative effect that the acquisition of a portion of the property has on the value of the remaining land held by the landowner. Cases on just compensation are numerous, and it can often be a struggle to determine under the standard exactly what would make the landowner whole. At McNees, we regularly litigate this issue. For more on this topic, see the information on the following screen.